Welcome back to Holocaust, Genocide, and International Law. This is Class 3, Legal Reckoning with the Crimes of the Holocaust, International Criminal Process. Here's a breakdown of today's class. In Part 1, we'll look at an introduction to international criminal law. Previously, we've only discussed public international law, where states are liable in international law. International criminal law applies to individuals. In Part 2, we'll look at the IMT, the International Military Tribunal at Nuremberg. And in Part 3, we'll look at the later Nuremberg trials. Before we turn to today's lecture, let's do a quick recap of Class 2, Legal History of Genocide. In Class 2, we looked at the drafting history of the Genocide Convention. We also looked at the elements that were included and those which were specifically left out of the convention definition of genocide, such as a protected group based on political views. We looked further at the Article 2 convention definition of genocide, which includes an actus reus and a mens rea for perpetration of genocide, the actus reus being the prohibited acts, and the mens rea requiring two types of intent: general intent to commit the underlying crime, as well as the specific intent, the dolus specialis, which is the intent to destroy in whole or in part a national, ethnical, racial, or religious group as such. We also looked at the ancillary crimes, that in addition to direct perpetration of genocide, there are crimes for attempt, conspiracy, direct and public incitement of genocide, and complicity in genocide. And when proving genocide, it must be done at a level beyond a reasonable doubt. Let's look now at the extraordinary legal act that immediately preceded the drafting of the Genocide Convention, where crimes on an international level were proven in a courtroom, with the world watching in a first-of-its-kind trial in lieu of executions following the end of World War II. Part 1, Introduction to International Criminal Law. Today we're spending an entire lecture looking at the international legal process that brought individuals to justice after World War II. A good place to start our lecture is to look at what is international criminal law. It is individual criminal responsibility for international crimes, as opposed to state responsibility for acts, which is generally found in public international law. Now, what is the function of international criminal law? Arguably, it provides accountability in the face of impunity or no responsibility if nothing were to be done. Now, what are a few ways to deal with the aftermath of war and war crimes after a war? There is the classic option throughout history, which has been done, summary execution, or some sort of show trial where evidence is low and judgment is carried out without delay, and then persons are promptly executed. Another option is to do nothing and allow perpetrators or alleged perpetrators of crimes to walk amongst the regular public without having faced any consequences for their actions. A third option is to turn to the courts, and there was this turn to legalism after World War II and use of the law to show that there is accountability and a fair process for handling crimes. The courts and the court process show that there is accountability at the individual level for international crimes, because recall, when we looked at public international law coming into the 20th century, there really was just state responsibility. However, even with courts and a legal process, you'll see, even especially in Nuremberg, that there's political involvement in sentencing. For example, at Nuremberg, there was political pressure to use execution as a punishment, whereas in modern criminal tribunals, the politics at play is that there's a desire to restore peace, and often sentences are light, right? So persons convicted of crimes against humanity might get the same or less punishment as a person who sells drugs in the United States. Another function of international criminal law is to try to redress some of the social malaises that occurred during the crimes, to provide an opportunity to establish the facts of a given situation or an atrocity situation. Another function of international criminal law is to represent the interests of victims. And in theory, international criminal laws and tribunals are supposed to contribute to international stability by basically taking the bad guys, if you will, out of circulation and putting them in prison if they are convicted on the charges that they have been alleged to have done. And then there is the argument that international criminal law can create or stop conflict. That's quite controversial. Many scholars think that no matter how many criminal tribunals you have or how much criminal law you have, it's not going to stop the conflict, right? Because murder is still illegal and there are still punishments for murder in America, and murder continues to happen. Now, also look at, when we discuss Nuremberg today, the interplay of international criminal law and the domestic system. International criminal law has actually been highly influenced by the domestic system, and we'll see this specifically with regards to Nuremberg and the way the trials were carried out and the methods of procedure that were used and rules of evidence, for example. A lot of these procedural rules are drawn upon from the domestic systems. So let's get started. Part 2, International Military Tribunal at Nuremberg, Road to the IMT. At the end of World War II, 55 million were dead, and an entire continent was in rubble. There was agreement that those who brought about this destruction should be punished. The question was, how? In January 1942, members of the 9 occupied countries in Europe, sitting as governments in exile, issued the St. James Proclamation, which said at the end of the war, those responsible for war crimes should be punished. And then in 1943, in October, Churchill from the UK, Roosevelt from the US, and Stalin from the Soviet Union issued the Moscow Declaration Statement of Atrocities, promising that the major war criminals will be punished by a joint decision of the governments of the Allies, and also that the Allies would return accused Germans for trial by the country in which the atrocities were committed. But in general, there was a lack of consensus amongst the US, UK, and Soviet Union as to what to do with the perpetrators of these crimes. In the US's view, initially, it was that Germans should be summarily executed. This was the view of Henry Morgenthau, President Roosevelt, Secretary of the Treasury, who wanted to summarily execute 2,500 top Nazi officials as part of his plan to pasteurize and strip Germany of its industrial capacity so that it could never again in the future wage war. Morgenthau's foil was Henry Stimson, who was President Roosevelt's Secretary of War. Stimson wanted a legal approach. He wanted trials. And in the end, this legalism won out. But public opinion in the US still trended towards shooting or executing Nazi officials. The problem after World War II is that people were too interested in punishing war criminals, whereas today, if you look at the ad hoc tribunals or who's being brought or not being brought to the ICC, today the world really isn't interested in punishing war criminals. So it's interesting to kind of look at that difference in perspective from the end of World War II to the present day. For the US, it was going to put on trial the starting of an illegal war. And to the US, the Holocaust was initially, at least at the IMT, a secondary issue. To the UK only agreed to trials after first the US wouldn't budge about summary executions, and then also the Brits were outraged when it came to light that Stalin was really interested in executing 50,000 or 100,000 Germans. There was tremendous public pressure in the UK to punish Germans because the Brits, as a people and a country, were so deeply affected by World War II. The Brits were putting on trial at the IMT their own suffering. And finally, the Soviet view. Stalin really wanted, as we mentioned, to execute people, and he said so at the Tehran summit. He gave a figure. He had a really punitive attitude towards Germany. It was, for the Soviets, a more of a punitive gesture. In May 1945, at a UN conference in San Francisco, there was an agreement reached by foreign ministers of the 4 allied countries, so we bring in France to the fold now, for an international military tribunal for top Nazi officials to be tried, and where it would be independently determined the whole question of each defendant's guilt or innocence based upon evidence and the law. So, right, legal-based decision. And the next month, in June 1945, was the London Conference, where the war's victors met in London and essentially decided to call the tribunal the International Military Tribunal. At the conference was U.S. Supreme Court Judge Robert Jackson, who was offered the position of chief prosecutor at the IMT. He was the only U.S. Supreme Court justice to ever take a leave of absence from the court and then later to return. It was decided that the prosecutors and the lawyers would be from the 4 allied powers only, and that there would be 8 judges, 1 primary and 1 alternate from each country. It was also at the conference in London where the IMT Charter was drafted, and we'll have a look at that in just a minute. What was the IMT? In June 1945, the Allied powers met in London to establish the contours of a tribunal that would hear evidence and pass judgment on Nazi officials who had allegedly committed atrocities during World War II. At the time of the conference, the tribunal was also given a name, the IMT, International Military Tribunal. It was to be the first court ever created by international agreement of the United Nations being the countries that banded together during World War II to fight the Axis powers, and not the United Nations supranational organization that we think of it as today. I suppose cynically this would be where one could argue that this is the genesis of where the victors of this armed conflict decided to sit in judgment on the vanquished, but the legacy of Nuremberg deserves a much more positive reflection than that. The judges at Nuremberg were going to be called upon to prosecute international offenses on behalf of not only the states to which they belong, right, but also others, all other states, the United Nations. It wasn't just about justice for the 4 allied powers in principle. Nuremberg was conceived and can only really be understood as a revolutionary event in the development of international law. With the IMT Charter and with the judgment at Nuremberg, international law was now binding on the individual. And this view and understanding is really also confirmed in something that General Telford Taylor, the U.S. Chief Counsel for War Crimes under Control Council Law Number 10, which we'll discuss in the last part of class, and who also was involved with the prosecution at Nuremberg, when he was asked about the major significance of Nuremberg, he said that it was those portions of the judgment dealing with the area of personal responsibility for international law crimes. So that's, the crowning achievement and legacy of Nuremberg. The tribunal was also, in addition to meting out personal responsibility in international law for individuals, was also created in the mind of reconstruction of society. Now we'll look at certain particulars of the tribunal statistics and particular information about the defendants in just a little bit. I'd like you all to take a well-deserved break from listening to my voice for a little bit and watch the documentary that's linked on this page, The Nuremberg Trials. It was a documentary put together by PBS in 2006. And even if you've seen a number of Nuremberg documentaries, I'd like you to watch this one again and look at it and think particularly about legal features of the trial. For example, what did each of the Allied powers envision for justice after World War II? What fair trial protections were put into place with the Nuremberg Charter? What were some of the more persuasive ways of introducing evidence at the trial? And how was the courtroom, for example, altered to both facilitate a trial of multiple defendants and also bring the trial to the watchful eyes of the world? We'll catch up on the other side of this film. Welcome back. I hope you've had the opportunity to look at the documentary on the Nuremberg trials with more of a legal perspective than you would have previously. Let's now look at the legality of the creation of the IMT. Never before, as you heard in the documentary, had this type of international tribunal been attempted, because under classic public international law, military tribunals, or courts of occupation, were allowed under the laws of war to try criminals. So here are the victors, who were also the occupiers, who were also the Allied powers, were exercising their joint collective right to try the Nazi leadership. But this was the first court to apply the law of the IMT Charter, plus use customary international law to prosecute and punish international crimes. The IMT charter was assigned as part of your reading for the week, and I encourage you to go back and look at it again. It's not very long, it's very simply written, but it clearly sets out what the IMT is going to do, what types of crimes it has jurisdiction over, what defenses are not allowed, what are some of the fair trial protections listed, and these types of disclosures or information included is really important to have been included in the charter, because there was a real stress on making this outwardly seem to be a fair trial process with due process, because military tribunals are typically not considered as being very demanding of fair trial and due process standards as in civilian courts. So it was important to sort of list out ahead of time what these fair trial protections and crimes to be prosecuted and defenses that aren't going to be allowed, what all of those are going to be. The court and the process. Was it partial? Was it impartial? The judges and the prosecutors for the tribunal came from the winning side. There weren't any neutral judges to be found because the United Nations represented the whole world except for those Axis powers that banded with Germany during the war. Chief Prosecutor Jackson and Soviet Judge Nikitchenko were actually involved in drafting the IMT Charter at the London Conference, so there was an issue about there being really no separation of powers. The individuals who created the rules of the court were the ones who were essentially deciding the guilt or innocence of the parties by using those very rules that they developed. Some other issues of impartiality are that there was an issue with Russia having been Germany's ally involved in waging an aggressive war in Europe. The accused at the tribunal were actually sort of silenced when they brought up Allied or Russian conduct. And at the start of the proceedings, it was alleged that the Russian judge drank a toast to the hanging of the accused, and the charging documents omitted things that the Allied powers could also be accused of, for example, carpet bombing and the use of certain types of weapons. Criminal procedure at the IMT. It'd be really easy to just take pot shots at the aspects of the IMT that don't meet our fair trial and justice standards of today, such as prosecutors and judges being from the Allied countries and it amounting to so-called victor's justice, or that one of the crimes that was charged at the tribunal was really only rooted in Anglo-American law. That's the crime of conspiracy. But that belies the fact that there were many achievements in the fair trial and procedure aspects of the tribunal that can still be seen in international criminal law today. Essentially, the IMT Charter and the IMT at Nuremberg set in motion the criminal procedure that we still use in international criminal law more than 70 years later. And if you first look at the IMT Charter, Article 16, it lays out certain fair trial provisions, and it includes that proceedings be translated into a language that the defendant understands, that the defendant has a right to be given an explanation with respect to any charges, that the defendant has a right to present evidence himself or through counsel, that he has a right to cross-examine witnesses, and all of these fair trial rights can later be seen reduced to international agreements in the Universal Declaration of Human Rights only a few years later, as well as the International Covenant on Civil and Political Rights. And in addition to fair trial provisions, the IMT at Nuremberg was involved in this sort of unique and ultimately really successful and lasting merger of common law and civil law procedure for how to carry out a trial. And this might be best explained by a few examples. So in the common law, we have an adversarial approach to trials, which is where the attorneys lead the arguments and ask questions of the witness and sort of guide the trial. Whereas in civil law countries, it's an inquisitorial process where the judges typically lead the trial by asking the questions of the witnesses. While at the IMT, they ultimately decided on using the common law adversarial approach where the attorneys would guide the process. But then with respect to evidence in the indictments, they used more of a civil law approach. With respect to evidence, it was the decision that all evidence with probative value would be admitted. And now in the US, the standard would be higher. There are much higher rules and standards for evidence in common law in the US tradition. And then with respect to the indictment, they followed the civil law approach in an indictment containing full particulars of the charged crime. So giving sort of like a full view of the information that the defendant was being charged of, and it was also translated into a language the defendants understood. So then some of the other criminal procedure issues at the IMT included that defense counsel were all Germans. And then there was, and one of the other criticisms of the tribunal there was an issue about equality of arms. And that includes that the defense had an inadequate time to prepare. So the trial only occurred maybe 6 months after the end of World War II. The defense weren't given the or really any access to prosecution archives. The prosecution, through a multitude of investigators, had searched all German archives, which had been confiscated, in order to prove their case. And defense counsel didn't get to search the archives themselves, and they were also unable to search foreign archives. In addition, there were no appeals permitted in this trial process. So it was a one trial and then a conviction, possibly an execution, no appeals. So in the end, it seems apparent that criticism is warranted, but it's also really important to look at this through the lens of the period and how not 1 year prior, the notion was simply to summarily execute Nazi officials and think no further about it. Jurisdiction of the IMT. Jurisdiction essentially answers two questions: who the court can try, and then second, for what crimes the court can issue a judgment. The first is called personal jurisdiction, right? Who the court can try. So the mandate of the tribunal was to try leaders who act in the interests of the European Axis countries, whether as individuals or as members of organizations committed any of the following crimes, which were crimes against peace, crimes against humanity, war crimes, and conspiracy. And Article 7 of the IMT Charter specifically stated that an official position was not a bar to prosecution. The official position of defendants, whether as heads of state or responsible officials in government departments, shall not be considered as freeing them from responsibility or mitigating punishment. This is different than traditionally under public international law, where heads of state can't be put on trial. So that's personal jurisdiction. Subject matter jurisdiction, again, it looks at what types of crimes is the court competent to issue judgment over. And Article 6 of the IMT Charter said that the court was competent to issue judgments on the crimes against peace, war crimes, crimes against humanity, and common plan or conspiracy. Article 6 described crimes against peace as planning, preparation, initiation, or waging of a war of aggression, or a war in violation of international treaties, agreements, or assurances, or participation in a common plan or conspiracy for the accomplishment of any of the foregoing. War crimes was defined in 6b as violations of the laws or customs of war. Such violations shall include, but not be limited to, murder, ill treatment, or deportation to slave labor, or for any other purpose of civilian population of or in occupied territory, murder or ill treatment of prisoners of war or persons on the seas, killing of hostages, plunder of public or private property, wanton destruction of cities, towns, or villages, or devastation not justified by military necessity. Crimes against humanity was defined in Article 6C as murder, extermination, enslavement, deportation, and other inhumane acts committed against any civilian population before or during the war, or persecutions on political, racial, or religious grounds, and execution of or in connection with any crime within the jurisdiction of the tribunal, whether or not in violation of the domestic law of the country where perpetrated. Plus, a fourth crime was criminalized, which was a common plan or conspiracy to commit any of the foregoing crimes. And then those are responsible for all acts performed by any persons in execution of such plan. Again, this was really a theory of liability that was common to common law, but not necessarily unique to common law. And the theory behind it was that crimes and atrocities were not single or unconnected, but they were the inevitable outcome of a basic criminal conspiracy. The Americans were tasked with proving the crime of conspiracy. The Brits were tasked with proving crimes against peace. The French and the Soviets were tasked with proving war crimes and crimes against humanity. The French for the Western Front of the war, the Soviets for the Eastern Front of the war. The judges at the IMT held that these crimes over which they had subject matter jurisdiction from the IMT Charter were declaratory of customary international law existing at the time of the offenses. So even if they hadn't been reduced to a treaty or a covenant or an agreement between nations, they were declaratory of customary international law at the time of World War II. And we'll discuss some of the controversies surrounding that decision and outcome from the judges for each of the crimes in a moment. Defenses to the 4 crimes prosecuted at the IMT Nuremberg. Article 8 of the IMT Charter says that the fact that the defendant acted pursuant to order of his government or of a superior shall not free him from responsibility, but may be considered in mitigation of punishment if the tribunal determines that justice so requires. Essentially, this means that the argument that I was acting on superior orders is not a defense, but if the defendant is found guilty of a particular crime, it could be used as a mitigating factor when it comes to sentencing and the degree of punishment he's going to receive. The tribunal confirmed its reasoning of the no defense for superior orders in its judgment when it said that a soldier was ordered to kill or torture in violation of the international law of war has never been recognized as a defense to such acts of brutality, though as the chapter here provides, the order may be urged in mitigation of the punishment. The IMT tribunal also introduced the concept of what's kind of called a moral choice. And essentially, the court looked at whether the subordinate faced a situation where there was no moral choice. For example, where there was no freedom to choose between actions that were right and wrong without that subordinate suffering for them. Prior to the IMT, German law, American law, and British law had accepted a limited notion of a superior orders defense. But before the IMT tribunal opened, the Americans and the Brits changed their laws and essentially went to trial at the IMT based on this new law. There would be no superior orders defense. The trial. Having just watched the documentary on the Nuremberg trials, I don't want to belabor in great detail every aspect of the trial, but I do want to highlight certain components that we will be able to compare and contrast with other criminal trials that we look at in this class. So first, as we previously discussed, the judges at the trial, there were 4 main judges, 4 backup judges, one each from the US, the UK, France, and the Soviet Union. The court was a specially constructed courtroom at the Palace of Justice. Courtroom 600 was particularly reconfigured to be able to hold all of the defendants, all of their attorneys, and provide for simultaneous translation of the proceedings into 4 languages. The prosecution was headed by Supreme Court Justice Robert Jackson. He's the most well-known of the prosecutors, and he opened the prosecution's case with the famous speech that included the phrase that the 4 great nations, the Allied powers, stay the hand of vengeance. Is very powerful. The prosecution case took 5 months to put on. It was largely a trial by documents, which if you had a jury, you'd know perhaps you'd lose a jury. You'd lose the interest of a jury with a trial by documents. But understanding the importance of both showing shocking and horrible things to the decision makers, the judges in this case, and also to be able to capture attention in a very visceral way. In addition to trial by documents, there were also almost 36 live witnesses, and there was a very impactful film put together on Nazi concentration and prison camps. After the prosecution rested its case, the defense case began. As far as we know, the defendants at the IMT never killed anyone by their own hand. They were, as we've discussed, 24 individuals charged as representatives of the Nazi regime. 21 were tried, all pled not guilty. 6 former Nazi organizations were also indicted, and the attorneys were all German, and some of the attorneys were also former Nazi Party members. 80 witnesses testified for the defense, including the majority of the defendants, most of whom said they either didn't know the atrocities had been committed or that they were done on orders of the dead, including Hitler, Himmler, and Goebbels. The court began delivering its verdicts on September 30th, 1946. They included 12 death sentences, 3 life sentences, 4 long prison sentences, and 3 acquittals of individuals. As is well known, Hermann Goering ingested cyanide before his scheduled execution to escape public execution. The Nazi Party leadership corps, the Gestapo, the SS, and the SD were all found guilty of being criminal organizations, and that 4th crime of conspiracy that the charter was competent, the charter gave the tribunal competency to issue judgments on. That crime only attached to the crime of waging an aggressive war, and only to those defendants who participated in a concrete plan to wage a war of aggression. Basically, the court found that mere knowledge wasn't going to be enough. The IMT at Nuremberg disbanded after only this one trial, but Robert Jackson, chief prosecutor, told U.S. President Truman that there was a need to carry out further trials against other Nazi entities and persons, including the industrialists, the militarists, the politicians, diplomats, police officers, police officials, and others. And by UN resolution of the General Assembly on October 31st, 1947, there was a recommendation that all member states continue with unabated energy to carry out their responsibilities as regards to the surrender and trial and of war criminals. And we'll look at that continuing mandate in a moment. But first, let's look at what the court at the IMT said about each of the charged crimes. What did the IMT have to say about the crime of crimes against peace? IMT judgments recognized that aggressive war was the supreme international crime for which even heads of state could be brought to account. The tribunal also said that crimes against peace was not ex post facto, so creation of law after the fact to apply to a situation that occurred previously, because leaders who purposefully attack neighboring countries without cause must have known their actions were illegal, and it would be unjust to let them get away with it simply because no one had previously been charged with the crime. But there were criticisms of the crime, notwithstanding the court's statement that the law was not that the crime was not ex post facto. It was questionable as to whether it was a crime under then applicable customary international law, because illegal does not mean criminal. The relevant treaties at the time forbade only the resort to war, not the planning, the preparation, initiation of war, or conspiracy. And the Kellogg-Briand Pact didn't deal with individuals, only states. And the court ignored the reality that violations of the Kellogg-Briand Pact were not really treated as criminal, such as when Russia seized locations in Manchuria, or the Italians invaded Abyssinia, and the Italian king was recognized as Emperor of Italian East Africa by the UK and France. In addition, the IMT relied on draft treaties of mutual assistance from 1923, unratified Geneva Protocols from 1924, and a resolution of the League of Nations, right, the precursor to the UN, as if those documents were binding. And the tribunal didn't define what, quote, aggression was, but still managed to convict people of it. What did the court have to say about the crime of war crimes? War crimes is perhaps the least controversial of the charged crimes at Nuremberg, because violations of the laws of war and customs of war have been prosecuted in the past and continue to be prosecuted, even if they weren't based on leading treaties at the time. The IMT also rejected notions that the rules of war had become obsolete. It was determined that Germany's total war was impermissible. And finally, What about the charged crime of crimes against humanity? At the IMT, the crime of crimes against humanity was essentially where crimes that would later be called genocide or crimes that were protected by the later Convention Against Torture were tried, with the caveat that, unlike today, back after World War II, there had to be a war nexus such that there would not be any convictions for actions that took place before World War II during 1933 and 1939. That leaves me with a question to you. And what, in your minds, are the greatest legal legacies of Nuremberg? And interestingly, perhaps it was what was arguably defended as custom as a means to bring about this type of criminal trial at the end of a terribly devastating war, that those items that were declared as custom have over and over again been reduced to treaties, right? Because we discussed in class 1 how after, in this post-World War II period, there's been an increasing interest in codifying international law, right? So taking what is custom and reducing it to written treaties, written laws. And so after the IMT trials, we had first the Genocide Convention and the Universal Declaration of Human Rights and the International Covenant on Civil and Political Rights and the Convention Against Torture. And then fast forward a few decades and you have the ad hoc tribunals and the International Criminal Court. And what do they have in common with the IMT at Nuremberg, right? They have reduced to writing crimes, international crimes. They have reduced to writing international fair trial protections. So perhaps Nuremberg's greatest legacy is that 70 years after the IMT, we now have an extensive body of codified international criminal law. Final thoughts on the IMT at Nuremberg. What role did the Holocaust have during the trial? The IMT is often erroneously thought of and remembered as this trial where the Holocaust was put on trial. But if you recall, the trial was really about starting an illegal war, which was the crime of waging an aggressive war. But there was considerable evidence regarding the mass murder of the Jews and others that was front and center at the trial. And as you saw in the documentary, and as we discussed, there were documents reflecting anti-Jewish measures, and especially with regard to proving the crime of crimes against humanity, evidence was presented about the extermination of hundreds of thousands of Jews. There was eyewitness accounting of the extermination of Jews in Poland, right, where 90% of the pre-war population of Jews were murdered, and also in Lithuania, where 90 to 95% of the pre-war population of the Jews were murdered. There was evidence about the gas chambers. There was evidence about the experiments that were carried out on the targeted groups. And in the judgments at the IMT, there was an entire section dedicated to the persecution of the Jews, which included these early estimates that have now been confirmed of 6 million Jews murdered during the Holocaust. One of the really important legacies of the IMT, and which has proven to be invaluable in the decades following the trial, was the preservation of evidence. With only the benefit of being sort of 1 year removed from the war, as Professor Basler describes in his book, the historiography of the Holocaust at the IMT was really imperfect, but the extensive documentation that was collected at that time for the trial has now been reviewed and re-reviewed by lawyers and scholars and others. And over the last 70 years, there have been efforts and the abilities to make better sense and draw more fully conclusions about what happened during the war. So the evidence gathering and document preservation part of the tribunal is also perhaps one of its greatest achievements and lasting legacies. Finally, part 3, the later Nuremberg trials. Initial plans, as we discussed, had been to conduct subsequent IMT Nuremberg trials for other Nazi officials who weren't prosecuted at the initial trial. But this notion was scrapped because of increasing tensions between the Allied and occupying powers. By way of background, prior to and immediately after Germany's unconditional surrender on May 8, 1945, which put an end to World War II, the Allied powers, the US, UK, France, and Soviet Union, gathered at Casablanca and Tehran in 1943 and Yalta and Potsdam in 1945 to discuss the conditions of a German surrender, including what post-war Europe would look like, and also the division of Germany into zones of occupation. The US, UK, and France governed occupied zones in Western and Southern Germany, right, while the Soviet Union governed its zone in Eastern Germany. And the decisions on matters affecting all of Germany were meant to be decided collectively by the Allied powers. Berlin was jointly administered by all of the Allied powers, and the occupation was meant to be only temporary. With that in mind, the prosecution for these others who weren't brought to trial in subsequent IMT trials were basically left to the occupying powers. The prosecutions would apply the law that came out of the IMT Charter and the IMT Judgment, and documents such as the Moscow Declaration, which we discussed from 1943, and the IMT Charter, and resolutions of the UN from 1946 and 1947, which we also discussed, essentially underscored that war criminals are subject to trial and punishment independently of the time and place of the commission of the crimes, so that the Allies could basically go to the ends of the earth to find these people and prosecute them. Control Council Law number 10 authorized each of the occupying powers to carry out prosecutions in their particular zones. And they did, and we'll discuss them. We're going to look at the trials mainly in the US zone of occupation. The United States, as an occupying power, put on 12 additional trials, which have come to be known as the Nuremberg Military Trials, or the NMT, between 1947 and 1949. The UK, France, and Soviet Union, as occupying powers, also conducted trials, but the US trials are the most well-known and were the most extensive in terms of the number of individuals convicted. It is notable, though, that in the UK trials, unlike in the trials conducted in the US zone of occupation, the IMT decisions were not treated as irrefutable proof, but only as arguments along with other facts and circumstances presented in each of the cases. Back to the US, though. The US put on military trials because they were known as military trials because they were put on by the US Army, but they were staffed and presided over by state judges and other judges from the US legal community. The indictments at the NMT charged conspiracy to commit war crimes and crimes against humanity. No one was convicted of those. War crimes, crimes against humanity, membership in Nazi criminal organizations, which were determined by the judgment of the IMT, and crimes against peace, but those were charged in some trials only. The NMT had similar processes and procedures to the IMT, and so it opened them up to similar criticisms about the trials themselves, including that they were viewed by West German authorities as judicial assassinations, and the laws were ex post facto. Thus, the principles from the NMT and the IMT were never applied in the courts of the Federal Republic of Germany. We'll look at this more next week, but the hallmarks of the justice system in the FRG after occupation ended in West Germany was really focused on mass rehabilitation, pardon, and release from responsibility of Nazi war criminals instead of judicial punishment and imprisonment. Less than 4 weeks after the IMT judgment, the US military began their trials at the NMT. There were a dozen of them, and we'll quickly look at the subject matter of the 12 of them, and then I'd like to return to one of the trials and take a little bit of a deeper dive into it. So there was the doctor's trial, that put on trial 23 doctors. There was the German Air Force Field Marshal Erhard Milch trial. That was the trial of Hermann Goering's deputy. There was a justice trial where 16 leading Nazi jurists and presidents of special courts who had actively participated in racist policy were put on trial. The first SS trial relating to camps, mines, and factories, the Flick trial, Farben trial, the hostages trial, the second SS trial, the Einsatzgruppen trial, the Krupp trial, Ministries trial, and the High Command trial. Going back to trial number 6, the Farben trial. The Farben trial was one of the 3 trials conducted against industrial and financial magnates of the Third Reich. That included the Flick trial, as I said, the Farben trial, and the Krupp trial. And this is where the directors of monopolies in Germany were found to bear responsibility for their active participation in the Hitlerite aggressive policy to prepare and initiate and wage war, and the mass plunder of occupied countries, as well as the abduction into slavery and exploitation of hundreds of thousands of deported citizens. Now, as a litigator in international human rights law, I always find it interesting and maybe a little bit exciting when these types of historical cases make their way into current opinions in your U.S. jurisprudence. And the decision, or language from the decision of the Farben case at the NMT was most recently featured in a Supreme Court case from earlier this year called Jesner versus Arab Bank. And in that case, plaintiffs had brought an action against the Arab Bank alleging aiding and abetting of terrorist activities allegedly committed by Hamas that amounted to wrongful death because of these terrorist acts on behalf of the plaintiffs and their representatives. And in that case, the Supreme Court Justice Kennedy reached back into this historical jurisprudence and looked at the Farben case for guidance, because one of the issues in the case was whether, under this particular law in the U.S. called the Alien Tort Statute, which allows foreigners to come into U.S. courts and bring actions for violations of international law, whether the international law covered just individuals or did it also cover corporations. And so Justice Kennedy looked at the Farben case and found that, and I'll quote here, he said, although the military tribunal used the term Farben as descriptive of the instrumentality of cohesion in the name of which the crimes were committed, the tribunal noted that corporations act through individuals. Farben was itself not held liable. So Justice Kennedy in the Supreme Court, amongst many other authorities, relied on the Farben case for the principle that the individual is liable in international criminal law, but the corporation is not necessarily liable, right? Because the court noted that the Farben court said that corporations act through individuals. So you hold the individual liable, not the corporation. And so in the Jesner case, Arab Bank was found not to be held liable. But again, it's interesting and exciting, and it just shows the lasting power of the IMT and NMT jurisprudence, in that more than 70 years later, that is the type of resource and case law that the Supreme Court is looking to when making these tough decisions. Now, originally, the plan for the NMT was to hold at least 36 trials. But by the time 1949 rolled around in 1950, the world was a really different place than it had been shortly after the war. Communism was flooding through Eastern Europe, and the Iron Curtain had come down. Germany was now becoming a friend to the Allies, and the Soviet Union was now the enemy. And you could see this in things like the sentencing, even at the end of the 12, or the 12 NMT trials that were carried out, the sentences became lighter because there was more campaigning by Germany to free those who had been convicted. Because again, the their list of things alleging that the trials were improper. They weren't legal because no war crimes were committed. They were using ex post facto laws. There was victor's justice, that the individuals were just following orders. So by 1959, the U.S., given the sort of geopolitical pressure that it was facing with befriending Germany, being more skeptical and maybe fearful of the Soviet Union, the U.S. High Commissioner for Germany began pardoning or reducing the sentences that had been given out by the NMT. And by a decade later, by 1958, the last of the defendants convicted in the NMT trials walked out of Landau prison as free men. And going back to these industrialist trials, the industrialists Krupp and Flick had their empires returned to them, and persons who had admittedly supervised the execution of more than 800 Jews had been set free 6 years after the war. And tellingly, in the words of Ben Ferencz, one of the chief prosecutors of the NMT, chief prosecutor of the Einsatzgruppen trial, in fact, it was very appropriately said that justice was the first casualty of the Cold War. What was the legacy of the NMT then? Unlike the IMT, or actually like the IMT, the NMT trials also provided extensive historical records with more than 1,000 witnesses and tens of thousands of documents. But unlike the IMT, and what was incredibly valuable, the Holocaust was a prominent feature of the NMT, and through this legal process, it was established more how the Holocaust was actually carried out. The NMT, so the U.S. zonal trials, applied the IMT charter and judgments as precedent. And the NMT defined the crimes that were charged using elements, right? We've got, as we described with the crime of genocide last week, crimes have elements. They have an actus reus, the prohibited act. They have the mens rea, the mental state you have to have, those sorts of things. The NMT trials really fleshed out the crimes using elements and set the foundation for modern international criminal law. It also, once again, confirmed individual criminal responsibility in international law, and established a new norm that the accused can't assert immunity from prosecution because he acted in accordance of the laws of the state at the time, right? So simply because a law under the Nazi regime was permitted a certain act didn't mean that the person was not guilty of committing an offense simply because he was following that law. And the NMT trials also took the standard of proof that we discussed last week, right, beyond a reasonable doubt, seriously. If the evidence wasn't sufficient against some of the charged defendants, there was no conviction. And this confirmed fair trial procedures, right? If all the U.S. cared about were putting persons in prisons and filling up the prisons, then that wouldn't have mattered, right? But evidence and making sure that the crimes were actually proven beyond a reasonable doubt was really important. But to end all of this, the lasting unfortunate legacy amidst all of these great achievements of the NMT is that criminals literally got away with murder. As Michael Basler points out in his book, people in the U.S. who are convicted of insider trading get longer jail times than did Flick and Krupp and IG Farben for developing and mass producing the gas for the gas chambers during World War II. And with that, we reach the end of class 3.